Buying a commercial property is not just about agreeing a price. Behind every transaction is a legal process involving title investigations, searches, contract, finance, tax, and risk allocation. And if problems are missed during the purchase, the buyer inherits them. In England and Wales, buying a commercial property requires detailed legal due diligence before contracts are exchanged. The buyer's solicitor is responsible for investigating the property and identifying legal, financial, and practical risks before completion. Because once contracts are exchanged, the buyer becomes legally committed. The transaction usually starts with the heads of terms. This sets out the commercial agreement between the parties, including purchase price, completion date, whether the property is sold or vacant possession, any conditions attached to the transaction. These terms are usually subject to contract, meaning they are not legally binding, but they shape the entire transaction moving forward. Title investigation. This is one of the most important stages. The buyer solicitors review land registry documents, title plans, restricted covenants, rights affecting the property, mortgage, charges, third-party interests. The key question is simple. Does the seller actually own what they are selling? And can the buyer use it as they intended? For example, restricted covenants may prevent certain business uses. Rights of way or easements may affect development potential. And positive covenants may create financial obligations which are ongoing. Searches and inquiries. The buyer's solicitors also carries out searches and raise inquiries with the seller. This includes investigating planning issues, environmental risks, fire safety compliance, asbestos, service arrangement, disputes affecting the property, and the seller usually replies to commercial property standing inquiries known as CPSEs. These replies are critical because a buyer may later rely on them legally. Finance and tax. Buyers must also consider the wider financial position. This includes stamp duty land tax or land transaction tax if you're in Wales, VAT implications, mortgage funding, surveyor's costs, legal fees, land registry fees. Many inexperienced buyers focus only on the purchase price and not the transaction costs surrounding it. Once investigations are complete, the parties negotiate the contract. This sets out the completion date, what is included in the sale, risk allocation between the buyer and the seller, and the seller's obligations before completion. An exchange of contracts, the buyer becomes committed to the purchase and assumes the risk in the property. This is a major legal turning point. And on completion, purchase monies are transferred, the transfer deed is completed, ownership passes to the buyer, and the buyer takes possession of the property. The buyer's solicitor then deals with stamp duty filings and land registry registration. Looking at practical risks, the biggest mistakes usually happen during due diligence. For example, a buyer purchases a commercial property believing it can be redeveloped, only to discover restricted covenants and planning limitations preventing the proposed use. At that stage, the buyer already owns the problem. So buying commercial property is not simply a transfer of ownership, it is a legal investigation into risk. The contract, title, searches, and replies to inquiries all determine what the buyer is actually acquiring. Because once contracts are exchanged, most problems become the buyer's responsibility. I hope you enjoyed this video. I'll be grateful if please like, comment, subscribe. It's a Legal Development Limited, and if you have any questions, please comment below. Thank you.